Okay, good morning, everybody. My name's Ashley. Anybody who came to the last talk will know who I am, but for anybody who wasn't there, I am a solicitor at Allen Janes LLP in High Wycombe. My specialism is in estates, wills, trusts, and I've emphasis towards dealing with beneficiaries or individuals with learning difficulties or other vulnerabilities that might arise. Today's session is specifically on wills, trusts, and estate administration, and with an emphasis on considerations where you do have vulnerable beneficiaries, some of the impacts that might have on how you decide to structure things and decisions you take. So the PowerPoint that I'm going to go through is the handout that will be circulated later. If you have any questions, though, as we go along, make a note and we'll go through those at the end. So when you do have an estate or affairs that potentially involve vulnerable beneficiaries, we do have some really specific additional considerations over and above sort of the average person. And when I say vulnerable beneficiary, that can be somebody with any sort of learning difficulty. It can be somebody who is physically disabled, or it can be somebody that suffers from something that makes them slightly more susceptible to social pressures. So in particular, if we've got people with alcoholism, drug addictions, they would also be classed as vulnerable beneficiaries. And if you've obviously got somebody with dementia and later in life, that can also arise. But for the most part, actually, we tend to be looking at parents making considerations for their children. So it tends to be going down the generations rather than up. Some of the key considerations you do have when you've got a vulnerable beneficiary are things like how funds will be managed for them. So one of the biggest risks that arises if you leave or give money directly to a beneficiary and they're an adult, you have no control over how that money is spent or managed on their behalf. If they have capacity, that is it. It is up to them to make wise choices. You can obviously try and point them in the right direction, but you've really got no control. If they lack mental capacity, you would need a court protection deputyship in order to manage those funds on their behalf and have, again, regain control. So this is one of the issues that arises, particularly where we've got, say, younger beneficiaries who've inherited from their grandparents, and a legacy is left in the will of, say, £20,000 for good measure. To all grandchildren, but one of those grandchildren does have something that makes them vulnerable. If they are an adult, there's nothing that you can do about that. They receive that money, and either that money is managed on their behalf with something like a deputyship, or if they do have capacity, you try and talk them into doing sensible things, but it does create a real issue. I have put on their lasted powers of attorney as well. If there are powers of attorney in place, it can be a good way to help somebody manage their affairs. Where there is capacity, however, the attorney under lasting power of attorney is supposed to do what they're told by the donor. So that one's a little bit of double-edged sword, but does technically allow you to manage funds on somebody's behalf. Next one is social vulnerability point. So like I said, where you've got a beneficiary who does have capacity, but is vulnerable to being swayed. Again, if they're an adult and money's left to them in the right fashion, there's nothing you can do about that. Where they're children, there are some things that you can do about it. You can definitely manage the money on their behalf until they get to the age of 18. And then in a couple of slides, I cover off one of the workarounds that we can do where that is the case, but they're getting towards the age of 18. You want to maintain that assistance for a bit longer. And then the final consideration, which does arise quite a lot, are means tested benefits. So if you have a beneficiary that is in receipt of means tested benefits and they are left a legacy under will, so use the grandparents example that we gave at the start, if that gift is in an outright fashion and it tips them over the means tested capital threshold, so £6,000 is the lower threshold, £16,000 is the upper threshold. If they are over that, they will immediately lose their access to means tested benefits. And once the legacy takes effect, so the person who made the gift has died, there's actually nothing that that beneficiary can do to reverse that effect. They do have to accept the legacy and use it through until they're back below thresholds, and they can then reapply for assistance. So it's quite a painful process. It means that somebody who is in receipt of means tested benefits is actually much worse off than their counterpart who's never relied on it, because they immediately lose that access to help and have to use the legacy, probably in ways that it wasn't really intended to cater for their day-to-day expenses, and which tend to be higher, generally speaking, if you're in receipt of means tested benefits anyway. And just an additional point at the bottom to say that beneficiaries can't vary their entitlement away. It is something that I get a lot of questions on, actually, and usually in circumstances where it is too late to really do anything, if you have a good Google, you will find references to deeds of variation and occasionally to deeds of disclaimer on the internet, and they're a mechanism whereby, as a beneficiary, you can alter the destination of a legacy that you've been left under a will to redirect it. And a lot of people try and use that mechanism to do what we want wills to do, which we'll cover shortly. You can't do that. If you have received a legacy, the act of redirecting it by deed of variation, it's what's known as a tax fiction. So it, in the eyes of the DWP, the local authority, it's not really a thing, it is a gift. And they will treat it as deliberate deprivation if you enter into one. So options you have to protect the interests of one beneficiary, where you're clear that you've got one. You can put in protections under your will, and again, we'll cover that in a bit more detail going forward. The aim with wills of that nature are to avoid funds passing directly to that beneficiary, so we haven't got that deliberate deprivation issue. Instead, the funds are directed for their use, but are never put into their control. These tend to take the format of trusts, which is point number 2. Trusts can be set up during your lifetime. They can be set up under your will. It's much more common, actually, to have them set up under the will. And the structuring of trusts can get quite complex. There's no real way to sugarcoat that, actually. Trusts are a very legalistic concept, but in its simplest form, it is passing funds to a third party on the understanding that those funds are not for their use, and telling that third party who those funds should be used for. So that's where you have the trustee, and trustee is that third party who looks after funds on behalf of somebody else. There are a whole plethora of different types of trusts, and the main ones we were going to be covering off in this session are what's known as discretionary trusts. So the trustee is given a wide scope of discretion as to how the funds are used. And that tends to be the best way in terms of means tested benefits to offer that protection and flexibility, and allows beneficiaries to still be benefited in a way that protects them and takes into account their own circumstances. And the third one I've put is guardianship. So anybody who's a minor really is a vulnerable beneficiary. So if you're ever looking at a will or planning around children who are minors, we would urge you to consider guardianship as one thing. You can put in place guardians as a matter of course, simply through a deed. It has to be in the format of a deed, but you can name individuals, name them as the guardians, and sign it as a deed, and that would be effective. Because wills are executed as a deed, that is the place where you see them most often. Guardianship will only take effect if both parents have passed away. But obviously, for a guardian to be taken into effect, that means both parents have passed away before that child has gotten to 18. So in those circumstances, you really do want to have all bases covered. If you do not name guardians, your close family members can step in to care for a child. You can end up with difficulties where people are arguing over who's best placed to do that. So if you have named your guardians, you've made that decision for them. The one issue that really does crop up where you've got family members who've stepped in to help is they do not acquire parental responsibility for that child. So they can take care of that child day to day. But for instance, if they wanted to move the child from the country, even take them abroad actually, they can have real issues where they are not legally appointed and have not been given parental responsibility. So without a formal guardianship having been made, they will have to apply to the court to get that consent. It's very expensive and stressful in circumstances where you don't really need it. So always a key one that I thought was worth putting in here is if you are looking at your wills and you do have minor children, appoint guardians, have that conversation. It can be quite an awkward conversation to have and a bit of a difficult one because it's not circumstances you really want to think about happening, but it saves so much heartache, actually, having just done the difficult thing at the outset, thought it through and thinking through would be best place. The other little caveat I put on that is most people choose to appoint their parents, which is in theory fine, but bear in mind your parents' own age and possibly have that conversation with them, make sure it's something they'll be able to do, but possibly even as a stopgap. It's not necessarily the worst thing in the world, but there is a practical consideration to the appointment of guardians. So wills. When we are drafting wills and we know that there's a vulnerable beneficiary, our main aim is always to ensure that the funds can be managed on behalf of that beneficiary, but in a way that's not going to jeopardize their access to means-tested benefits and in a way that is still protected. So where we've got vulnerable beneficiaries, like I said, who do have capacity but may not make the smartest choices, this can be a really good mechanism of still having them as the focus of the will and the intention, but making sure that somebody else is overseeing what actually happens with those funds. I've put here the worst case scenario, and this really is actually the worst case scenario where you do have a vulnerable beneficiary, and it's the typical simple will. When people come to me and say, my affairs are really simple, I just want to leave everything to my husband, wife, and then on to our kids. And if one of those children is vulnerable, you've immediately got a problem, actually. Because on that second death, if nothing else has been done, that child immediately gets or is entitled to that share of the estate. And then we've got back to the start with issues around deliberate deprivations, if they try and move the money away from themselves in any way. We've also got the issues of if they are just not suited to manage funds on their own, nobody's able to step in. If they're an adult, they can do whatever they want to with those monies. So if you have written a will in simple terms and this circumstance does arise, there is a little glimmer of hope. The glimmer of hope only really comes around, if I'm honest, if the beneficiary is under the age of 18 still. So if you have an estate and the beneficiary is under 18, they can't give what's called good receipt. They can't receive money legally because they're not an adult. So a form of trust is immediately put in place anyway under the law. It's what's known as a bare trust in most cases. There are some slight quirks to that, but we won't delve into that too deeply. But that bare trust is in effect someone saying, well, this person's not 18, so I have to look after the money for them, but it is their money. The way that that can be sort of, so in the strictest sense, once that child gets to 18, that money should be passed over to them. It is their money to do with as they see fit. If you've got a beneficiary with any sort of learning difficulty, or yeah, actually in this case specifically learning difficulties, and you know that they would not be able to manage that money, and also paying that money over to them immediately means that somebody needs to be able to manage their finances, and you have to apply to the court protection, which is a whole different ballgame. One of the things that can be done is to say, well, this money is being held on bare trust for this beneficiary, and I'm going to put it in a trustee bank account, and the money will be managed from that account on their behalf going forward. So it doesn't protect on the means tested benefits point. It's still their money. It would pass as part of their estate if something were to happen to them. If they got into financial difficulties, actually, it's money in the pot that needs to be used to fund whatever there is that needs funding. But by keeping in a trustee bank account, the people named on that account as trustees are the ones who can manage the money going forward. So it slightly fudges a way to work around having sums of cash that have been left to minor children who will never be able to manage it without you having to necessarily immediately go to the court of protection to get the authority. Trustee bank accounts, as just a slight aside, are a really specific thing, and one of the reasons you want a trustee bank account and not just a general bank account is it's clear on the face of it that the money's not yours. So when you open a trustee bank account, you have to name who the trustees are, you have to name who the beneficiaries are, and the bank have that noted. To change the account holders, you need to appoint new trustees, and there's a whole process for doing that. But it also means that if something were to happen to you, it's clear that money does not form part of your estate. It is being held for a third party. And then there's whole mechanisms in place to appoint new trustees to be able to take that forward, so somebody else can continue to manage it on their behalf, rather than, like I said, it's a bare trust, it just defaults back to them. Or if it's just a normal bank account in your name and something's happened to you, either it forms part of your estate because nobody knows, and a designation on an account is not enough really to save it. It gets really convoluted actually trying to unpick that. So it is something worth bearing in mind. So what do we want to see when we've got vulnerable beneficiaries? So as I hinted at earlier, where we have an estate and we know that there are going to be vulnerable beneficiaries involved, we want a trust. And specifically, we want a discretionary trust. So I put here the ideal will, where vulnerable beneficiaries are involved, is a will which names trustees to manage the funds on behalf of the beneficiary and names guardians if they're under the age of 18 as well. That form of will just leave the estate to the trustees on discretionary trust. And that would mean the trustees have complete discretion, as the name suggests, on how funds are managed, how they're applied for that beneficiary. They can do that in whatever way is deemed most appropriate. The trustees are guided by a letter of wishes because the will actually doesn't really say a lot. The will says, I give my estate to you as my trustees to do with as you see fit. But these are the classes of potential beneficiaries that you can benefit. And you do tend to name a group of people, children, their children. You can name more distant relatives if there's a reason to do so. And we always bundle in charities for good measure to make sure that there is somebody that could benefit if all else fails. But the letter of wishes that sits alongside it is not a legal document. It is meant to be, in your own words, telling your trustees, one, why you've done what you've done, and then letting them know how you actually want them to apply funds. So where you have vulnerable beneficiaries, it allows you to be really personal. It allows you to be specific to their circumstances, the things that they're likely to need, and to ask the trustees to bear that in mind when they're exercising discretion. So traditionally, when we prepare wills of this nature, we will prepare the first draft of the letter of wishes for the clients, give it to them for them to review. It can make any changes they want to, but it's very important that actually that letter of wishes is there to sit alongside the will from the outset. And we would put in there, my child is in receipt of means tested benefits. I would like to protect those as much as possible. Please bear that in mind when exercising any of your powers to appoint out capital or income. But in any case, my overriding objective is that my child is cared for in whatever way is necessary. So that is the crux of a discretionary trust in the simplest terms, because we can really go down a rabbit hole with them. For our purposes, there are two real types of discretionary trusts that we want to look at. So one is what's called a relevant property trust, and this is the overarching term for most types of discretionary trusts. It doesn't place any limitations on the trustees. It simply does, as I said, gives them the estate to deal with as they see fit between any of the classes of beneficiaries. As to income, capital, making loans, they can do whatever they want to, actually, as long as they can show that it's in the interest of the beneficiaries and not in their own interest, because that's one of the things trustees can't do. The issue that we have with these types of trusts is they have historically been designed to go on for quite a long time. And in other spheres, we use them as a tax planning measure. So they are often employed by people with relatively large estates to move money through generations without suffering a 40% tax bill every generation, every 30 to 40 years. As a result, over the years, HMRC and the government generally have clamped down on these. Gordon Brown did a really good job of clamping down on these. And so relevant property trusts are taxed as harshly as they can be. Any income tax they pay is at the highest rates. Capital gains tax is paid at the highest rates. They have lower allowances to set against those in the first place. They also suffer inheritance tax charges every 10 years. So it's not the perfect way to shelter funds, to move them outside of your estate. It's at a lower rate than 40%. It's at no more than 6% every 10 years. So still attractive to people in that sense. But there is that ongoing charge. And actually, if it's a big enough trust and it's paying money out, every time it pays money out, that money will be subject to a tax charge as well, of always less than 6%. The idea being that every 10 years you kind of get clobbered with 6% of whatever the value of the trust is. So the tax treatment for these is complex and is very harsh. You tend to put these in place where you've got a beneficiary or a class of beneficiaries. If you've got more than one person actually that you want to benefit on these trusts, that's one of the reasons you do this. And if they don't meet the definition of being vulnerable, which I'll get onto in a second, but if they don't meet those criteria and you still want the protections actually that a discretionary trust can manage, you'd include these. It's also worth adding with the tax point, and specifically the inheritance tax point, it depends a lot on the size of your estate. So if your estate is within its inheritance tax allowances, that 10-yearly charge isn't really a problem, at least not for the first 10 years. It's reassessed every 10 years. So if the assets grow in size and they tip over the thresholds of 325, then you potentially look at a tax charge. But the income and capital gains taxes are always taxed at the harshest rates for relevant property trust. So useful to know they do come into play, but generally speaking, not where you have a beneficiary that is in receipt of any form of disabled benefits. So the second type of discretionary trust is what's called a vulnerable or disabled persons trust. This is a type of trust that was put in place specifically to have the benefits that we have with a relevant property trust, but without the harsh tax treatment, because it's clear that the reason this trust has been put in place is because there is somebody who needs the support and help. So in order to qualify, the beneficiary has to be in receipt of certain benefits or has been assessed as lacking capacity. So if you've got a beneficiary that is on disability living allowance, PIP, or is generally just deemed to be mentally incapable, this type of trust is open to them. The funds in this structure of discretionary trust are still given to trustees and they are still given discretion as to how it is applied. However, the vulnerable beneficiary is named as the primary beneficiary of that trust. So that's why I said it can be a bit tricky actually if you've got more than one vulnerable beneficiary or if you want to benefit multiple people, but we can structure wills to take that into account. But the idea being you'd have your one primary beneficiary that this trust is really set up to protect, and then you've got a class of other potential beneficiaries that are identified who are secondary. And the intention is that those secondary beneficiaries shouldn't really be benefiting while the primary beneficiary is alive. So during the primary beneficiary's lifetime, the trustees have to pay all income and capital to them. They don't have that discretion. There is a small allowance that is made, so of up to £3,000 a year or 3% of the total value of the trust, whichever one's lower, that can be paid out to any of the other potential beneficiaries in a given tax year. And that is really to try and compensate them if they've incurred expenses and bits and pieces helping out. But other than those small exceptions, everything else has to be used for the primary beneficiary. But the application of that income and capital is still discretionary. So that is the reason why this still works for means tested benefits and any other type of benefit really, because the beneficiary doesn't have the right to demand it. If the trustees choose to, they can just not make payments out. They can let this trust fund accumulate and bubble up. But if the trustees assess the vulnerable beneficiary as needing something and they're in a position to help, they can make payments out in whatever way they think is suitable. So the reason we like these trusts is there's no inheritance tax charge every 10 years. Any income and capital gains that arise are taxed on the beneficiary, who normally will be a lower rate taxpayer. So the tax treatment generally is much kinder, and it's on the face of it, treat as if it is their money. So actually, from an inheritance tax point of view, going forward, we don't have the 10-year charges, because when that primary beneficiary dies, the value in the trust is treated as if it had belonged to them. They can't leave it under their will. They've got no control actually over where it goes. But from a tax perspective, it's taxed as being in their estate, and the trustees would have to deal with the tax consequences as a result, and then can choose to benefit any of the other potential beneficiaries. So that's one of the reasons we include secondary classes of beneficiaries, as to who would get this money when the primary beneficiary isn't around anymore, if there's any money left in the pot, because there's no guarantee there would be. The trustees might have very good reasons to pay all of the money out during the primary beneficiary's lifetime. So the reasons why this type of trust works for means tested benefits. Like I said, beneficiary isn't deemed as owning anything. They have a potential right to benefit, but no actual right to demand any funds. Anything that they do receive is passed to them at the trustee's discretion. Number two is a little bit of a health warning. So when trustees are exercising their discretion, they need to really carefully think actually about how best to support the beneficiary, but not jeopardize their means tested benefits. So as a general rule, trustees will not hand capital funds over to a beneficiary. They also need to be a little bit cautious about giving them an income stream. So those two things tend not to be in the remit. The trust will generate income, and it will sit within the trust, helping to build up the piggy bank, as it were. And then rather than giving the beneficiary capital, the trustees will use that money to buy things for them instead. So examples I've given here are ones that come from trusts I've dealt with recently. So upgrading home facilities, buying a property actually for the beneficiary to live in. That property will be held in the name of the trustees. So the beneficiary doesn't own it. They can't do anything with it really. But it's been designated by the trustees as a place for them to live. It can pay for carers. It can buy them a car. It can do solar panels. The list is quite extensive. What they're not able to do is to pay for general living expenses. So there is a rule within the DWP guidance that says that if trust funds, or any other source of income actually, but trust funds in this case, are being used to fund day-to-day general living expenses, so utility bills, council tax, any food really, anything that's just a day-to-day part of your general living expenses, the DWP will treat that as a source of income. And that will ultimately then impact the access to means tested benefits. So it's one of the exclusions. It tends to be trustees will use money to buy big capital things, or again, as an example, for an estate, a trust that I'm managing, the trust regularly pays for sensory experiences for the investment of swimming classes or anything else that sort of enriches their lives, but does not fund their day-to-day living expenses, because we're not allowed to. But it is one of the things that the trustees do need to be quite careful about when it comes to managing trust funds. I've put a note at the bottom to say both of these types of discretionary trusts are things that you can set up under your will, but you can also set them up during your lifetime. So we see them more often under wills because, as a general rule, people don't have that type of cash to be able to hand over to trustees to be managing for a third party while they're alive. Some people do. And if you are in a circumstance where you do have spare reserves of cash and want to set up a trust, then it is a good option. It gets that 7-year clock running. It's treated as a gift. So it's a good way of moving money outside of your estate and immediately using it to benefit the people you intend to benefit anyway. The structuring for that is putting in place a trust deed during your lifetime that sets out the terms of that trust. And then once that has been signed, you have to hand over the proceeds, so the trust funds, to those trustees for them to start managing. And as soon as the funds are handed over, that's when the trust begins. So there's a few key considerations if you are thinking about putting in place discretionary trusts. First one is, who are the trustees? This needs to be a really practical point. So you need to think of adults, can't be children. They need to be sensible. You need to trust them to be impartial and quite level-headed. and they need to not be afraid of paperwork, because one thing that does come with trusts is paperwork, which is point number 2. But just before I move on to that, just to say I've put a specific note to say you need to trust the beneficiaries to honour your wishes. Like I said, with discretionary trusts, you are handing funds over and saying to that trustee, do with this as you will, but here's what I would like you to do. It's non-binding on them what your letter of wishes says. It is just guidance. So there needs to be quite a high level of trust, and knowing that that person will understand your beneficiaries' needs. If they've got no concept, then that can also be a little bit problematic. If you are setting up trusts in your lifetime, you can be the trustee of your trust. You just can't be a beneficiary of it. So one of the rules is that it needs to be funds you don't need anymore. So, but if you are in a position to do that, you are able to continue managing those funds on behalf of that beneficiary by setting up this trust structure, but naming yourselves as the trustees of it. So point 2, administration. Trusts come with a lot of administration. So we had a couple of years ago the Trust Registration Service introduced, which is a branch of HMRC, and it effectively records all express trusts. So any trusts that have been made on purpose have to be recorded. It allows HMRC to monitor what trusts exist. You have to include the names of the trustees and the names of the beneficiaries so far as you're able. With a class of beneficiaries, you just need to identify the class. It allows HMRC to check the tax treatment of them as being correctly dealt with. So, for instance, the relevant property trusts, discretionary trusts, that's really important for this because they do suffer these harsh tax treatments. So it notifies HMRC that they exist, and HMRC will check each year to make sure that the tax requirements are being met. With the disabled persons trust, there are still tax requirements to be met, even if it's not being taxed as harshly. So trustees will need to file annual tax returns. When they're exercising their discretion, they also need to formally record that to evidence it going forward more than anything else. But it can arise as an issue where people they just sort of make a decision and pay money out. You have to formally record it. And trustees are supposed to have things like annual meetings, a bit like a company actually, annual meetings to set out where they are, what they have, what are the beneficiaries' positions, is there any steps they should be taking over the next year. So because of all of that administration, trusts usually do continue to incur professional costs. As I just said, we help to manage quite a few trusts. If the trust fund is big enough, that's not really a problem. Where you've got smaller trusts, that can be a point of concern. So it's something to take into account when we're looking at whether or not discretionary trusts are appropriate, or if there's any sort of less restrictive way that we can achieve the protections that somebody's looking for. But ongoing professional expenses really are a consideration when looking at them. And then the last note was for lifetime trusts. If you are putting anything into trust, you have to stop benefiting from it. And this is something that people come a cropper of all the time, actually, particularly with their home. Anybody who says put your home in trust is a big red flag. You have to part with the benefit of any asset you're placing into trust. Otherwise, it's not truly a gift. So for an inheritance tax point of view, it's what's known as a gift with a reservation of benefit. It doesn't leave your estate for inheritance tax. For capital gains tax, however, it does leave your estate, and that can create a world of issues. So, and you can't, once you've given money to the trust, you can't then start to benefit yourself from that trust going forward. So say it is cash that you've handed over and it's being invested, and suddenly you fall on hard times, you can't then go to that trust and start taking the money for your own benefit. It becomes settler interested, but also it's a breach of the trust. So not a good route to go down. So that is the real health warning on if anybody is considering lifetime trusts. Like I said, they can be excellent forms of planning for the future, but you do have to be pretty certain that it's something you can do without going forward. You're gifting it away. It is no longer in your estate. It might still be in your control, but it's not something you can use. And the final point in italics does relate to lifetime trusts to say that if you are setting lifetime trusts and you've got beneficiaries under the age of 18, you need to be aware the HMRC will treat income that's arising from that as arising on you as a parent. It's an anti-avoidance point so that people don't move money into a trust, siphon off the income, or have the income taxed at their children's rates because they're higher rate taxpayers. So once they get to 18, that issue doesn't arise anymore. But lifetime trusts, not trusts on death, but only for lifetime trusts. If the child is under the age of 18, it's something to be aware of. And then final point from me is other things to just consider when we're looking at your estates overall, and things that can come into play. Pensions. Pensions are held as trusts, funnily enough, but as a general rule, they have their own schemes and set out who should benefit when. You can usually fill in expression of wish forms for the pension trustees. If you've got a vulnerable beneficiary, it's worth letting the pension trustees know that and asking them not to make direct payments out. Actually having a vulnerable beneficiary who ends up receiving a pension or income from your pension is still a problem. So it's something you will need to take advice on if that is one of the potential outcomes, because like I said, once they're getting an income, it will reduce their access to means tested benefits. Life insurance policies can pay out in one of two ways. They either pay out directly to your estate, in which case they're covered by your will, or you might have nominated people on the policy. And in that instance, it's good because you don't have to wait for probate. In most cases, life insurance will simply pay out to those beneficiaries on receipt of proof of death. But if you've named your vulnerable beneficiaries as the beneficiaries of the life insurance policy, they will receive that fund in an outright fashion. So if you do have life insurance policies that might be a possibility for, and you're reviewing your wills anyway, there can be good inheritance tax reasons not to have life insurances that pay to your estate. So if it's going to tip you into the inheritance tax regime, you don't want to do that. But if you're well and truly within your thresholds, that might be the easier thing to do. Just simply say to life insurance, pay this to my estate, and then it'll be distributed according to your will, but it will have to wait until probate before anybody can access those funds. The alternative, if you have a taxable estate, or we prefer to do it this way, is you can set up a lifetime trust that doesn't hold anything. We set it up with £10 normally, and it's what's known as a pilot trust. And that life insurance policy could be told to make its payments to that trust rather than to an individual. And then you've got the same benefits you've got of having the trusts we've talked about earlier, but in a structure where it can receive the money sooner, and then it can be managed without ever forming part of your estate and being suffering inheritance tax. So important point. And the third one is inheritance from grandparents, which is how I started off this session. If your parents are potentially considering benefiting your children and one of them is vulnerable, have a conversation with them. They can either structure it so it's a gift to you. If they really want to structure it as a gift to that grandchild, don't do it in an outright fashion, unless it's a very small amount. If it's a small gift, a token, then that's fine. But if it is any sort of larger amount that's really going to impact their access to means tested benefits, have a think about how best to structure that. And it might be to get them set up, particularly if it's a reasonable legacy that they want to leave to that grandchild, they would need to include trusts in their own wills. Because as we've said the whole way through this, if they simply leave it as a gift to that grandchild, there's no way once they've died to do anything about it without losing the means tested benefits anyway. So I hope that makes sense. That was a lot of information, so I do apologize. We will circulate the slides, but I will stop the recording now. And if anybody's got any questions, please ask.